Okay, Ms. Hastings.
May it please the court. My name is Madison Hastings, and I'm a student attorney with the University of Houston Law Center's Entertainment Law Clinic. I, alongside my co-counsel, Mr. Justen Slater-Barks, represent the appellant, Ms. Di Reed, in the case at bar. Appellant's argument will proceed in two parts. I will address the procedural issue as to why the district court abused its discretion by construing a challenge to subject matter jurisdiction as a motion for summary judgment without notice or an opportunity to be heard prior to dismissing the claims with prejudice. And my co-counsel will address the novel issue regarding Ms. Reed's trademark infringement and unfair competition claims. We respectfully request that this court reverse the grant of summary judgment by the lower court and hold that the abuse of discretion occurred for two reasons. First, Ms. Reed did not have notice that the motion would be construed as a motion for summary judgment. And second, she did not have an opportunity to be heard on the arguments raised sua sponte by the lower court, never briefed by either party, prior to the dismissal of her claims with prejudice. Turning to my first point. The district court abused its discretion when it concluded that Ms. Reed had noticed the motion would be construed as a motion for summary judgment based on its title and based on the anticipation that a dispositive motion would be filed in the case. The circumstances of this case render both of those bases insufficient to provide her with notice. Here, title of the motion was insufficient to provide her with notice that the motion would be construed as a motion for summary judgment when its substance was a challenge to subject matter jurisdiction contradicting that title.
What was the title?
The title was motion for summary judgment, Your Honor. Motions should be construed based on their substance rather than their title or the framing by the parties, as this court has repeatedly held, such as in Justen Industries versus Choctaw Securities LP and Lawson versus United States DOJ. And here, looking to the substance of the motion itself, the arguments were all challenges to subject matter jurisdiction. The challenges to subject matter jurisdiction were explicit, as the motion repeatedly concludes, quote, claims should be dismissed because the court lacks subject matter jurisdiction, as can be seen on the record at pages 218 and 220, and further concludes at the record on page 223, quote, because plaintiff has failed to plead any claims with original jurisdiction, there is no basis for supplemental jurisdiction. Where the explicit arguments, conclusions, and law cited in the motion all challenge subject matter jurisdiction without raising arguments of factual sufficiency, it was reasonable for appellant to conclude that these were challenges to subject matter jurisdiction and would be construed as such based on the substance of the motion rather than its framing or title by appellee. Therefore,
what did the district court rule? On what basis did the district court rule? I know you're saying it's not subject matter jurisdiction. As I recall, the district court found subject matter jurisdiction under the Lanham Act, right?
Yes, Your Honor.
Okay. So on what basis did the district court rule then?
The district court raised its own arguments regarding co-ownership of trademarks and—
Well, I know that your argument is the district court raised its own arguments, but on what basis did it rule?
It granted the summary judgment on the basis of prudential standing under Lexmark.
Okay, and so is your argument that the substance of the, whatever the motion was, summary judgment or not, did not argue that?
Yes, Your Honor.
Okay, so if I read through the memorandum, I would not see any mention of prudential standing or any of that? No mention at all?
No mention in the motion to dismiss, the motion for summary judgment, Your Honor.
Okay.
The substance of that motion was identical to a prior filed motion to dismiss for lack of subject matter jurisdiction, and the court concluded in its conclusion that it had subject matter jurisdiction, that Ms. Reed should have anticipated an intent to file a dispositive motion in the case. But the factual context here renders the basis an abuse of discretion.
So I was about to ask you, what is the standard of review that we are reviewing this under?
It's abuse of discretion, Your Honor.
Okay, so you can't, you have to show more than just an error, right? You have to show an abuse of discretion, and you just recited the district court's reasons. Why is that an abuse of discretion?
Your Honor, here it's an abuse of discretion because it's blatantly unreasonable given the factual circumstances in this case. Here, there was a motion that was initially filed as a motion to dismiss for lack of subject matter jurisdiction. It was withdrawn when the lower court determined or informed the parties that only one dispositive motion would be allowed to be filed in the case. And almost a year later, it was refiled identically with a new title and a new prayer as a motion for summary judgment. This timing was 9 months after the deadline for dispositive motions, 2 weeks prior to the deadline for a joint pretrial order, and within 4 weeks of the trial date. And the substance of the motion was identical. Therefore, appellant reached out to appellee to inquire what the motion was intended to be, shocked by the filing so close to the date of trial. Counsel for appellee affirmed that it intended to refile the prior withdrawn motion for lack of summary judgment as a challenge to, or prior refiled lack of subject matter jurisdiction as a motion for summary judgment. And so appellant responded to the challenges raised in the motion, and it openly characterized it as a motion to dismiss for lack of subject matter jurisdiction. And appellee replied relying on the same jurisdictional arguments they had previously used. Therefore, the district court abused its discretion in concluding that an anticipation of a dispositive motion was sufficient based on this factual context.
Were these procedural objections raised by your client at the time in response to the motion?
Yes, Your Honor. Ms. Reed, appellant filed a motion for a new trial, which was considered a motion to reconsider based on reconsider the...
No, I meant in response to the motion that you say was just a refiled, the same motion.
Yes.
After the date the dispositive motions were due, was an objection raised to that?
Yes, Your Honor. Appellant challenged, responded to the challenges for lack of subject matter jurisdiction at that time.
The question was you're raising procedural objections, right? It was filed late, it was the same motion. Were those objections raised?
No, Your Honor. The day after the motion was filed, the court, untimely, the court granted leave for that to be permissible, and then appellant responded to the motion based on the challenges contained therein. Turning to my second point.
Really want to hear about this procedure. So they file a motion that's identical to a motion on subject matter jurisdiction, which had been filed earlier.
Yes,
they
Your Honor.
just retitled it motion for summary judgment.
Yes, Your Honor.
And then the appellant filed a response to that motion.
Yes, Your Honor.
And the upshot of that response was?
Can you repeat that last portion?
What was the upshot of the response? What did they say in the response to the motion for summary judgment? What did your client say in response to that?
Appellant responded to the challenges contained therein regarding the lack of subject matter jurisdiction. And appellee replied to that response, continuing to raise jurisdictional arguments.
All right. So your complaint now is that because it was treated as a motion for summary judgment like it was labeled, that there's something you didn't get a chance to say that you would have said if it had in fact been a motion for summary judgment with content different from subject matter jurisdiction. There's something else you would have said.
That is correct, Your Honor. The merits of the claims were dismissed based on this idea of Lexmark prudential standing under a summary judgment standard, which my co-counsel will address further.
And then you file a motion for reconsideration.
Yes, Your Honor, raising some of those arguments related to the Lexmark prudential standing. However,
so the arguments that you would have raised in response to this motion for summary judgment, you raised in the motion for reconsideration.
Attempted to raise, however, it was denied. And
well, I don't understand what you mean attempted to raise. You filed a motion for summary judgment. I'm sorry, a motion for reconsideration. I'm sorry, Ms.
Yes, Your Honor.
You filed a motion for reconsideration, and you said what you wanted to say in the motion for reconsideration.
No, Your Honor, because there wasn't, appellant also attempted to provide evidence based on the merits claims, and the lower court determined that that evidence shouldn't be considered because it was redundant, while also finding that there was no evidence to support the claims. And my co-counsel will address that further, Your Honor. Yes. I see that I'm almost out of time, and for that reason, we would ask this court to affirm that, or to find that the lower court abused its discretion in construing the motion for summary judgment as a motion for summary judgment. And for that reason, we respectfully ask that this court reverse. Thank you.
Thank you, Ms. Hastings. Mr. Barks?
Oh, no, it's.
Yes. Yeah.
You call his name.
Oh, I'm sorry. Did I sure did. Excuse me. Go ahead. Yeah.
It's hard to see that clock, Your Honor. May it please the court, my name is Justen Barks. Jade is not Jade without Reed. The facts on the record support this. Only one single of the certifications before the RIAA, the Recording Industry Association of America, was certified gold. That was Miss Reed's single, Don't Walk Away. She led that song. We know that that song is important economically for the brand of Jade because it was used both with the performances to promote and advertise the performances of the counterfeit Jade group led by Ms. Marshall and Ms. Kelly, along with the guest Miracle Holloway in the United States, as well as following the district court's order denying the reconsideration in the UK at Wembley Stadium. In the record, you'll find both in support of the response to the purported motion for summary judgment, social media requesting where is Reed. You'll find in the record following the request for reconsideration motion for new trial, social media posts showing not only the audio of Don't Walk Away, but the music video itself. What's your favorite song? It's Don't Walk Away. Your Honors, Judge Graves, you asked, what do we not get an opportunity to provide in response to what we believed was a 12B1 motion to dismiss for lack of subject matter jurisdiction? The answer is clear. Tanya Harris quit the band in 1995. Reed went to Europe and toured solo in 1996. Miss Reed has performed 13 times in both digital streaming media during the pandemic and between 2020 and today as Reed of Jade or as Jade itself.
Well, counsel, those are facts.
That's right, Your Honor.
So I understood the district court to be ruling on a novel but purely legal question, and that is whether co-owners of a trademark, one owner can sue the other owners, which is an interesting issue, and evidently not one we've addressed, I think. So that's a purely legal issue, right?
It is, Your Honor.
What does it matter that we couldn't put in facts about these matters?
You're absolutely, Your Honor. I think the structure of the district court's argument is problematic for a number of reasons. We can reach the issue of joint ownership. However, the question of joint ownership in the context of statutory standing under Lexmark was never addressed. The district court essentially collapsed Justice Scalia's zone of interest test, which is divided between false advertising claims and those false designation of origin claims. In fact, Justice Scalia
Does that matter at all?
It does, Your Honor.
One co-owner cannot sue the other co-owners of a trademark for trademark infringement.
It does, Your Honor, because the question in trademark law, as this court is well aware, is whether there's a likelihood of confusion. The test for whether or not a party has statutory standing under the Lanham Act is a different question. That was the only one that was addressed. We would like an opportunity to address the issues of ownership and confusion, and we didn't have an opportunity to do that. I'd like to add...
You're saying that you would prove that they're not co-owners?
Your Honor, no. Specifically, there's two kind of diverging lines of case law. Our line of case law involving the Kingsmen, involving the band Leonard Skinnerd, discusses the likelihood of confusion issue with respect to the parties within a live performing or recording group that are the economic drivers of it. Your Honor, I'm happy to supplement
But
this.
in those cases, are the band members the co-owners of the trademark that is allegedly infringed?
I'm sorry, Your Honor.
In those cases, are the band members co-owners of the trademark that is allegedly infringed?
Purportedly, Your Honor, that is the issue.
I'm saying in the cases that you just mentioned, Leonard Skinner, whatever,
Yeah.
did it involve co-owners of a trademark who were suing each other for misusing the trademark?
Absolutely, Your Honor. In the Leonard Skinner case, the original members of the band formed a separate Leonard Skinner band and went on tour. Mr. Van Zant, who died in a plane crash, his estate held certain rights to the trademark ongoing because, as you know, in live music and performance service, we treat them slightly differently because the ongoing use of the mark in the minds of consumers continues to direct that source back to those rights owners. Because the estate was not given an opportunity to participate in both the record company's release of a new record and in this new band's tour, the district court was asked to consider whether or not an injunction was appropriate. The district court opined that it had not, the group had not, the estate had not met its initial high burden for injunctive relief.
Okay, what's the name of that case?
It's Grondin, Your Honor.
But isn't that different from the facts here? Here you have a co-owner suing co-owners about the mark.
Yes, Your Honor.
It's different categories of parties.
I think it's not. I don't think
So
that.
you're saying this is the same as the Leonard Skinner case?
I'm saying this is the same as
parties, categorically.
absent the fact that everybody's alive, Judge. Yeah. I don't think that matters in the context of the single source function of a trademark or the question of likelihood of confusion. Section 1125A of the Lanham Act allows any person to sue any person who believes that they're going to be injured for a misrepresentation of fact regarding the use of a trademark in commerce. Ms. Reed is not only a member of JADE, she is the core member of JADE,
But
and
in
JADE
the
is.
cases that have dealt with a co-owner of a mark suing a co-owner of a mark, do you have one of those cases where the court made a determination that the co-owner could proceed under a Lanham Act?
Sure, I will direct the court, and I'm happy to supplement this. This is in our record. There's a number of these cases. One is in front of the Trademark Trial and Appeal Board, Brock versus Turner, in which the putative owner and lead economic driver of this band, who had not even used the mark for over a decade, sued to oppose registration by a co-owner of a confusingly similar permutation of that mark. It wasn't even an identical mark. It was a confusingly similar permutation.
I have to tell you, that sounds different. That would be if two of the members of JADE went and tried to register JAYDE.
The registration doesn't matter, Your Honor. It just is because the only reason why that comes up is because it's an opposition proceeding before the TTAB. The reasoning of the Trademark Trial and Appeal Board goes back to the district courts and goes back to the circuit courts in identifying who the main economic driver of that trademark and that source is. Now, the court has the opportunity to remand this back to the district court to determine the question of ownership, which is the first part of a trademark infringement test, which would be the first part of a merits-based evaluation of whether trademark infringement occurred in this case.
But what's your answer to the ownership question? Who are the owners here, or the co-owners?
As to the registration, Your Honor, the co-owners are Ms. Marshall, Ms. Harris, and Ms. Reed. With respect to...
Okay, so having answered that question, sorry I'm cutting you off, but so one of your issues on appeal, which I thought we were going to address here, is this. Did the district court correctly determine that an individual owner of a federally registered or common law trademark has no right to defend or enforce her rights against co-owners?
Yes, Your Honor.
That was the issue that you presented in your blue brief.
That was one of them, Your Honor. I think, unfortunately, the district court didn't get an opportunity to get to that point. We can address that here. The question was collapsed. The question is about likelihood of
I
confusion.
mean, you said, did the district court correctly determine, so but now you say the district court didn't determine that.
It didn't make it didn't, I mean, Judge, the district court relied on a statutory standing of Lexmark and a misinterpretation of other intellectual property laws to reach the novel issue of whether joint owners can prevent confusion among consumers, ultimately landing on the statement in its order pursuant to our Rule 60 motion that joint owners of a trademark can sow confusion among consumers to their heart's content. That is what we're trying to prevent here.
I'm pretty sure the district court didn't put it that way, right?
No, I'm being a little hyperbolic, Your Honor.
The district court probably said co-owners can't sue the other owners.
No, excuse me, Your Honor.
No.
The district court specifically said that any of the owners could go out and use the mark on their own without any other person preventing them from doing so.
Is it unusual for three people to co-own a trademark?
Absolutely, Your Honor.
Okay, so since it's unusual, it's probably unusual for a reason, because of these kinds of practical problems that will probably arise.
That's correct, Your Honor.
But, I mean, that doesn't help a court, though. Like, what governs the rights of, I mean, so you can say the third person or the second and third people who own the trademark can't do X, Y, and Z, but how are we to know that they can't do X, Y, and Z? They're co-owners.
Your Honor, I think we need to go back to the principal issues of single source significance. Let's take the
What does that mean?
so when
It sounds like a legalism to me,
it's a little bit of
to a non-specialist.
Sure. So it's a little bit of a legalism, Your Honor, but the idea behind trademarks is that a mark itself identifies the source of certain goods and services. If we say Apple on a computer, or the hammer, you all decided the Jim Adler case a couple of years ago. The hammer is a source identifier not for Jim Adler, but for the services of Jim Adler's law firm. It doesn't even need to indicate which attorneys are working under that law firm that are providing those services, but when consumers within the jurisdiction that Jim Adler offers his services see the hammer, they know that there is a certain quality and control that's being exercised over those services associated with the mark. We know when we go to McDonald's, we're always going to get the same types of hamburgers, right? That's single source significance.
Okay.
In the case of entertainment services, courts across the country have acknowledged that there's some distinction. We have to identify that we're not manufacturing goods, that we're not providing corporate services. The services under an entertainment mark are personal services unique to the individuals of a group. Often, and in the cases that you have reviewed and the cases that were cited to the district court, entertainers have gone around this by forming so-called loan-out companies or other filing entities that consolidate some of those intellectual property rights so that the entity itself, as a corporate structure, controls who gets to do what. The entity will license out the rights, and the membership within that entity will control which members come in and out of the group. Okay?
Is that a trademark question, or is that a contracts question?
It becomes a contracts question, which makes your issue a whole lot easier. And the reason why this is a novel issue, when that occurs, when there's some sort of agreement between a group on how to use a mark, then we just look to the contract and you say, did you follow the contract?
Well,
However,
that would be decided by state court, right?
It sure would, Your Honor, but that's not what we have here. What we have here is a trademark. I'll point to the registration, which is not dispositive, as the court has seen in Lightfoot versus DeBrine. Often, the existence of a corporate filing entity can be problematic. But here we have individuals, three specific voices within a band, each who are a part of the unified source of the services and the goods that are sold to the public under Jade. And when the consumers look to go and attend a...
Counsel, I guess my problem is you keep wanting to focus on consumers being confused. But that's not why Ms. Reed is here.
That's exactly why Ms. Reed is here, Your Honor.
Well, it's not about her being in the group and Miracle Holloway replacing her, and she's saying you can't replace somebody else with me. And I mean, almost all of my favorite groups, most of the original members are dead. The Temptations, the Delphonics. I mean, I know if I go to one of these concerts, I'm only going to see one original Temptation. The others are dead. So should Otis just stop performing because everybody else in the group died? I mean, I understand what you're saying to me, but what we're talking about here, and we can talk about all this consumer confusion and all that, that's what I'm talking about now. But what we actually have here is a Lanham Act claim and a question about whether or not the co-owner of a mark can bring a claim against the co-owner of the mark. And the answer seems to be no. And I don't know how talking about consumers being confused helps get you to answering the question of whether or not one co-owner can sue another co-owner for using the mark. I mean, if a consumer goes to see Don't Walk Away is a really great song. I like it. I remember it. And if I go to see Jay, if the third person who's singing it is not there, then I know somebody else is singing it, but I just want to hear the song. So I think we need to be talking about the Lanham Act claim and a co-owner suing rather than consumers being confused about who's singing that song when they go to a concert.
Your Honor, 2 points in
All
response to that. The first, you're familiar with the Beach Boys.
Yes, sir.
What you've described.
Good vibrations, but yeah.
Yeah. What you've described is a case, it's called Reed, not our Reed, different Reed, where a member of the Beach Boys attempted to use the Beach Boys to go out and perform for the Beach Boys. And the other members of the Beach Boys said, who were still alive at the time, said, no. When people see you selling tickets to the Beach Boys, they expect us to be there. That's damaging our reputation because when we don't show up, people are calling us and saying, where are you? That's damaging our reputation because when we don't show up.
You're saying the facts regarding the Beach Boys are exactly the same facts we have here.
I think they're very similar, and I'm happy to supplement.
Very simple.
Very similar insofar as the Beach Boys were, and I don't want.
They were co-owners of the mark.
Yeah.
There wasn't any contract involved about who can do what.
Not in that instance.
Who can call themselves a bit. So it's exactly like these facts. Well, I need to go read the Beach Boys.
And I'm happy to supplement that for the court after we're done with the argument today. Quickly, I see I only have about a minute left, Judge. To the other point, I want to make clear one of the issues that the district court had in its initial order on the motion for summary judgment. While it was trying to figure out how to handle trademarks and joint ownership, it looked to copyright law and patent law. And it did what you're suggesting right now, which is to say, let's ignore consumer confusion. Let's look at copyright and let's say, there's joint authorship. Well, that's in 17 U.S.C. 204. Let's look at patent. It has joint ownership. Let's look at that. That's in 35 U.S.C. 263. There is no joint ownership issue in the Lanham Act, Your Honor, and that's why this court needs to reverse.
I guess if I were the judge, I would have looked at McCarthy first. What does McCarthy say about it?
Well, 2 points, Your Honor, and I'm going to quickly wrap up. First is McCarthy acknowledges that the purpose of the Lanham Act is the single source function, which cannot be severed. Otherwise, it destroys the purpose of a trademark. And second, McCarthy acknowledges the economic driver issue that I addressed at the beginning of my argument, that when there's a question among joint owners as to who is driving the source, who is the person that the consumers look to as the function of the source of those goods and services, you look to the economic impact. Thank you, Your Honors.
All right, thank you, Mr. Barks, and you've saved 2 minutes for rebuttal. Yes. Mr. Narvios?
May it please the court, my name is Attorney Jim Narvios, and we represent the defendants Joy Marshall and Tanya Harris, who are both co-owners of the trademark Jade, and we also represent a valid licensee, Miracle Holloway. I'm here with my law partner, Attorney Nimi Narvios, and I'd like to extend my gratitude in her hard work in being able to get us this far. And I want to express my gratitude to be in front of this court because it's always been a dream of an attorney like myself. And I want to say thank you to opposing counsel for that opportunity and thank the University of Houston for their resources. This case involves co-ownership of a trademark. It's very important to be very specific on that and what the Lanham Act was actually intended to create in regards to the construction by Congress. They created it for a specific opportunity to be able to clarify throughout all these years as the climate of our nation changed. So for example, they had advertisements come in. So that's why they created an extension in regards to unfair competition and false advertising. And as our climate of our nation changed, they clarified further and further and further. But one thing still remains, that the Lanham Act was created in order for infringers to be prevented from infringing from the rights of a rightful trademark owner. Today we ask for the court's affirmance in regards to the decision of Judge Sim Lake's granting of the motion for summary judgment for these 3 points. Whether co-owners to a trademark without an operating agreement can sue each other under Lanham Act claims, and whether Di Reed can sue a valid licensee who was given that license from a valid co-owner exercising their rightful conduct and their acts to be able to extend that particular right to Miracle Holloway. The second point is, did Judge Sim Lake sua sponte grant a summary motion for summary judgment in regards to statutory standing and the Lexmark test to the 43A claims? And lastly, which I'd like to address first, is the assertions by the opposing side in regards to a filing of a 12B1 as a motion for summary judgment in regards to whether or not they were actually confused in whether we filed a motion for summary judgment. So I'd like to start on that procedural issue at hand because I'd like to defend our business, and we'd like to take the opportunity to express to the court exactly why the record shows that opposing side was not confused and why Judge Sim Lake describes it as straining credulity. So first and foremost, on page 5 on the record, Your Honors, there is a lot of notice in regards to procedural history. We filed a motion for leave to extend in regards to filing a motion for summary judgment. Not a 12B6, not a 12B1. Opposing side asserts that we mistakenly filed a 12B1, but we never filed a 12B1. We filed a 12B6, which he corrected in his brief to this court. We effectively withdrew that 12B6, and as we withdrew that point did not matter anymore because we had withdrawn it. And specifically in that motion to withdraw, we withdrew and then we reserved the right to file a motion for summary judgment. Another point that points to the notice as far as our intention to file a motion for summary judgment. After filing the leave, we filed the motion. We entitled it Motion for Summary Judgment. Within the body and the substance of this motion, which is mischaracterized by the opposing side, it is not identical to our prior motion in regards to our 12B6. Yes, it did have substance in regards to subject matter jurisdiction, but nothing prevents us from being able to express that, and specifically, we only express that in regards to the supplemental exercise of the court under the state claims that opposing side raises. And so within the body and the substance of our motion for summary judgment, we express that motion for summary judgment evidence must be produced. We also express in the record that record was page 351. In regards to motion for summary judgment evidence is 349. And then we also express our motion for summary judgment standard, which is opposing side's necessity to be able to raise a genuine issue of material fact as a matter of law in page 351. Opposing side then files leave to reply, and that is labeled as a reply and a response to a motion for summary judgment. After the court granted it and signed an order for a motion for summary judgment, he then replies, and within that reply, which I would like to get into, he not only expresses acknowledgement of the motion for summary judgment and the ability to raise a genuine issue of material fact, but he also brings in the arguments of the merits of Lexmark's test and statutory standing. And so I'll get into that in my second point. And then finally, Your Honor, he sent an email which he submitted as an exhibit on page 906, where he stated specifically, I need to prioritize responding to your motion to extend and motion for summary judgment. And so we concur with the lower court's observation that opposing side's assertion that they were confused of this particular type of motion as it's straining credulity.
I have to confess, I don't understand what is at stake in this argument. I hear arguments about being confused and not being able to make arguments, but then I also heard that the district court allowed arguments to be filed, in a Rule 60 or whatever motion to be filed. I wasn't a district judge, so these numbers are, they're in the book somewhere. All the arguments were fleshed out, were they not? On this legal point that I thought we were supposed to be deciding here.
Yes, Judge Duncan.
So I just don't understand the harm of, if there was some confusion, maybe there was some confusion, but where's the harm?
There was no harm.
It's a friendly question.
Yeah, there was no harm in regards to Judge Simlake granting a motion for summary judgment because opposing side had the opportunity to argue and did argue Lexmark standard and statutory standing and argued within its merits and in fact submitted 19 pieces of exhibits that were meant to evidence the merits. And so they had an opportunity to raise and to argue these particular issues during the reply, and they did, instead of focusing on raising a genuine issue of material fact in regards to the issues. So the first point I'd like to bring in, and a question that I've observed that your honors have asked during the first part of the questioning is, can co-owners sue each other? The Lanham Act specifically states, and it's supported by federal law, that co-owners cannot sue each other because co-owners have an unfeathered right to be able to use their rights, especially when it absence.
That each co-owner does.
Each individual equal owner of the trademark, yes, Your Honor. And we can evidence the equal ownership of each co-owner through the registration papers. I'd like to point to y'all page 362. That is the registration papers that they filed in June of 2019, which opposing side has undisputedly accepted that they all own the trademark, they all signed it. So thus, they have an equal share and equal opportunity to exercise their rights as co-owners to the trademark Jade. But what's really fascinating to me is that despite the fact that they don't have an operating agreement that governs and limits the ability to use this trademark, there is something that I'd like to point to the court's attention, is that there was a past registration that was given for a trademark Jade. And that's on page 483. And if you look at each individual trademark registration, it specifies a statement of use, a class. And that's what's required whenever you register for a trademark, because you have to specify it. They don't want to prevent Jade cleaning product or Jade, airplane company. They want to give an opportunity for other people to be able to utilize a trade name and a mark. And so in that particular prior filing, which was in the past registration, it states in their statement of use, entertainment services, namely live performances by a musical group. And as that one expired, which I'd like to call to the court's attention, they did not own that. Somebody from the record label owned that. They, in turn, after it was abandoned for a while, went ahead and registered it once the opportunity arose. And once the opportunity arose in 2019, if you take a look at that new registration in 362, it states 3 different statements of use. One, where it says, namely, musical performances specifically for dance, for an artist performance. Singular, a artist performance. The next one is specifically, namely, for performances for a band, addressing multiple. Then the last one states, a artist and a producer, mainly for production and composing purposes. So I'd like to point to the court's attention that that's
Composing recording purposes. Would it be recording purposes as well?
the last one, yes, Your Honor.
All right.
Yes, Your Honor. So that's important to note, Your Honors, because whenever you register for a trademark, you make a statement of use, so that way you can be specific. These 3 ladies, Joy, Tanya, and Reed, they got together, they agreed that, hey, we're going to be co-owners to the trademark. They signed, they registered for this trademark, and they agreed that this was the way that it's going to be used. But I'd also like to call to the court's attention that throughout the course and the totality of the conduct, the circumstances in which these ladies conducted their business, they each individually celebrated not only working together and the hard work and goodwill that they've had in the past, but they wanted to benefit from that hard work and goodwill independently. And that's shown on an email on page 504 where Reed agrees to only work with Joy and not have Tanya. It also shows that Reed on page 501 suggested that they could possibly use a new name, which I'm not going to make any assumptions there. But I think the most important piece of evidence in the record is on page 343, which is Reed using the trademark Jade in a DJ Cassidy performance, which she proceeded to continue and do performances with DJ Cassidy over the course of time. That's the same exact way that our clients have exercised their rightful ability of their actual authorized conduct within the confines of the trademark.
You know, what strikes me is that while this specific issue before us may be novel, co-ownership of a mark, this problem has got to be common. I mean, you got a band, there's 3 people in the band, call them the Rolling Stones, call them the Beatles, whatever. I know there was 4 people in the Beatles, 4 people in the Beatles. And then they break up, and 2 of them want to go and be the Beatles, and they want 2 new guys. And then the other 2 say, no, you can't do that, that's not the Beatles. So how is, just as from a matter of the industry, how is this commonly recurring issue dealt with legally?
Yes, Your Honor. Judge Duncan, that's a very good question, and I think it's an important question to ask for the industry because we don't want our courts to be inundated with co-owners suing each other just because they don't agree with somebody, this is what the case is about. It's about
Well, I mean, Judge Gray's mentioned the Temptations. I mean, there's got to be a way of somebody who owns the Temptations saying, well, there's going to be a performance over here, and there's some guys over there, and we're agreed to call it the Temptations. But then there's some guys over here, and they want to call themselves the Temptations, and we don't want them to be called the Temptations because they're no good. Okay, so how do legally we deal with this? I guess that's just a background question from somebody who's very ignorant about this industry.
Well, an operating agreement. So what I would suggest is that, if given the opportunity, this court rule in our favor in granting the motion for summary judgment in regards to the issue of co-owners not suing each other, I would like to suggest, to respond to your answer, that an operating agreement should become a requirement in registrations involving multiple people.
Well, I mean, I don't think this court can say, here's how you have to do it. I'm just asking as a general background.
Yes, Your Honor.
How is it done?
The way that it's done is with explicit terms outlined in an operating agreement that governs the limitations and the processes of the way that this trademark should be held and conducted. Which brings,
And if someone violates that agreement, what then happens? Surely there are many cases about that, I don't know.
so what would happen, Your Honor, is that there would be a state law claim and it would be handled as a breach of contract claim, not a trademark infringement claim.
And there'd be an injunction. Yes. There would be no temptations.
Exactly.
On Saturday night, that's right. Okay.
And so that brings me to the next point is
So, I mean, that's what would happen here is that if we were to rule in your favor on the issues presented here under the Lanham Act, then Judge Lake has specifically reserved any ruling on the state law claims which would go to state court. I realize you would say that there's no liability there, but at least any of these issues, whether it's tort or contract or anything else, would be presented as non-Lanham Act claims in state court. Is that what's going to happen if we rule in your favor?
Yes, Your Honor, and that's exactly the way it was suggested in the cases Derminer and Picari. They stated that in a very similar situation of co-owners not being able to sue each other, and they're asking for an accounting and some sort of accountability for money that was made. It is their burden to be able to prove that, but in the venue of a state court, under the state court claims, the causes of actions, and potentially a breach of contract, but not in this court. Thank you, Your Honor. So it brings me to the next point. Can Miracle Holloway be held liable as a valid licensee? So first we ask, was she given a valid license? Well, there is a work-for-hire contract that was given to her, and that is on page 529 within the record. It represents a valid license that was given by co-owners Joy and Tanya. Our clients gave her a valid license. They were authorized to do so, and the conduct was within the confines of that contract because she was a work for hire. In no way, shape, or form did they make any misrepresentations of false statements saying that Miracle Holloway replaced Direed. Instead, it's very clear that Miracle Holloway, with her own right, her own career, and distinctive look, she looks completely different than Direed. And additionally, opposing counsel has presented in his exhibits screenshots asserting that there's a confusion in marketplace. Should the court consider this opportunity to argue any sort of confusion in the marketplace, I would like to ask the court, was those comments representative, and did they raise a genuine issue of material fact in regards to whether those clients and customers, potential customers, were actually confused? Well, I say no, because those screenshots say, is Direed performing? Jade is not anything without Direed. So it shows me that they're not confused. They know exactly who is performing and who's not performing, and thus there is no confusion and there is no display of economic damages. Which brings me to my final point, Your Honors, is opposing sides' assertions that Judge Sim Lake sua sponte grant the motion for summary judgment in regards to the reasons of the issue of statutory standing and Lexmark's test for 43A. We say, yeah, he had the right to. He had the absolute right to, because in Atkins, a case in the district court, it granted a motion for summary judgment for a claim of business necessity. And in that particular case, they did not raise business necessity in their motion for summary judgment, but the court ruled it sua sponte because, A, the requirements were met in regards to the showing that there was notice. Opposing side had notice because it's clear within their response, they thoroughly argued within the merits and addressed statutory standing. But should we hold the position of attempting to argue statutory standing, we ask, does the court and does Congress, did they intend for statutory standing under the Lanham Act to include a plaintiff like Direed? We say no, because for the trademark infringement case, co-owners of a trademark cannot sue each other. There can't be, so there's no standing there in regards to that. And so thus, the actions of the co-owners were authorized, so there is no proximate cause to be met there. There is absolutely no proximate cause. And then if you bring it for Lexmark's test, they also argue that, and within the record, it shows that their reply, it shows that they asserted that argument, and then additionally, they supported and brought forth all of the evidence necessary for them to support these merit-based arguments in regards to statutory standing and Lexmark. But if they were to argue that Lexmark does not apply to 43A1A, which is false association and false designation of origin, we argue that Lexmark applies to that. Their argument is that Lexmark, it does not apply to it. Well, our argument is that it applies the necessity of being able for opposing side to prove that there was a commercial injury in regards to business reputation and sales. And we believe that they're not able to reach that burden of proving that their evidence shows a genuine issue of material fact that there was that kind of injury, nor can she fall within that zone of interest or show any kind of proximate cause. But the reason that their argument that it doesn't apply to false association and false designation of origin, in which they're trying to bring Miracle Holloway in and our other clients vicariously and contributory liable for that action, is because Lexmark did not address it because it was not a cause of action in Lexmark. However, it was addressed in future claims, which went after in Palataria and Belmora, where it was a similar situation, and the claim was for false association and false designation of origin, in which the court held that the Lexmark standard and test would apply, and it would be necessary for them to be able to be shown some sort of commercial injury to business reputation and sales. So with that being said, Your Honors, we're asking the court to affirm the lower court's decision in granting our motion for summary judgment, and we believe that opposing side failed to show a genuine issue of material fact in regards to all of the elements of their claims. And additionally, we're requesting the court to affirm the court's decision to decline to exercise supplemental jurisdiction over the state law claims. And we ask that because we believe that opposing side has failed to show a genuine issue of material fact, show authority in regards to any cases. There is no case that shows that co-owners of a trademark can sue each other. It also did not present to the court any authority in regards to trademark owners giving a valid licensee a valid license and another co-owner being able to sue that valid licensee in regards to a situation similar to Miracle Holloway. And we believe that she has a valid license because it was exercised through the conduct of our client's rightful opportunity to exercise their rights as co-owners. And thus, we believe that our client's actions are authorized, and it follows the background and the substance of the Lanham Act, which was designed to protect trademark owners from infringers, which it clearly states that those infringers cannot be co-owners to the trademark. And we sincerely hope that the court affirm the lower court's decision and agree with Judge Sim Lake. And we hope that in the future we can continue to build upon the Lanham Act, further clarifying and codifying the court's decisions in order for us to avoid a situation like this. But I'd like to end with this statement, Your Honors. In situations like this, we all know that people change. People get confused, people's opinions change, people's perspectives change. Family members, people that feel close at one time, they become strangers, they become enemies. That's just human behavior and human nature. But what doesn't change is an operating agreement. And that's why we would like to encourage that in the future for the trademark office or in hopes for other courts to be able to codify that and the Congress to agree with that particular type of standard, to be able to add an operating agreement. So that way we avoid these particular types of situation. But absent an operating agreement limiting our clients' opportunities to be able to exercise their rightful conduct, does not violate the Lanham Act and the purposes and intent of the construction that Congress had intended, nor does it violate any authority that we have shown within our brief that co-owners cannot sue each other. And because co-owners cannot sue each other, we'd like to rest our case and thank the court for this opportunity.
All right, thank you, Mr. Narvios.
Thank you.
Mr. Barks, you've saved yourself only 2 minutes.
That's correct, Your Honor. There was a question about whether we were harmed. We were harmed. The language in the motion was about subject matter jurisdiction. As the court knows, subject matter jurisdiction can be raised here and now today before you for the first time. It is not a merits preclusive challenge. It is a jurisdiction challenge. The court can consider the pleadings. The court can consider facts outside of the pleadings. The court can reach and render determinations about which facts are dispositive of subject matter jurisdiction at that time. We included evidence to support jurisdiction for the court, not to support a Rule 56 motion for summary judgment on trademark infringement. To that end, the district court raised on its own statutory standing. And it raised statutory standing in applying Justice Scalia's zone of interest tests about reputational harm and commercial harm. Cases within this circuit, there are only 2 within this circuit that have discussed false advertising cases. That's Red River Federal Credit Union and Acresa Health. And they have acknowledged Justice Scalia's analysis that Section 45 of the Lanham Act specifically talks about false association, false designation claims, and not about false advertising. That's the whole reason why he went through the analysis, was to identify those claims. The question about an unfettered right of ownership comes from district court cases from well beyond this jurisdiction. First in Demeanor, where the court did not deal with false designation claims, but with dilution claims. And you'll recall that dilution requires ownership, Your Honors. Ownership of a registration, not of a right. And for those reasons, we'd ask this court to reverse and to remand pursuant to its considerations. Thank you.
Thank you, Mr. Barks. Your case and all of today's cases are under submission, and the court is in recess until 9 o'clock tomorrow.